soon burn, patiently awaiting to see Yeshua's return. With our eyes open, ears soon, full of confusion, aware that the negative thoughts create illusion. Positive thoughts become axis of motion, conquering complete control of the emotion. Forcing each shoulder on my back, avoiding my baby's obligations, just want me to learn hard for the mind. Talking full capacity when everything is blind. First person likes to be a cold world. Yet the wind of the roaring man, take us disappointed in the rainy morning. New world order, take advantage of a crisis, giving us the market obsolete for the prices. Built by the elite, we get a set to be complete after selling to us. First rebel, even notices.
What up, Demetrius? What up, folks?
Patiently awaiting to see Yeshua's return. What our eyes open, ears to avoid confusion, aware that the negative thoughts create illusion. Positive thoughts become axis of motion, conquering complete control of the emotion. If I sneeze shorter on my back, avoid all my baby's obligations, just want me to learn hard for the mind. Talking full capacity when everything is blind. Learn first life to be a cold world. Yet the wind of the roaring man, take us as you want it to be here every morning. New world order, take advantage of a crisis, giving us the market obsolete for the prices. Built by the elite, we get a sense of making the after selling to us. First up, I want people notices.
I'm going to go over some fundamentals for all the news and everything, probably for some people who have been doing this for a while as well. You know, I've been spending some time kind of looking around YouTube, and you know, this TDA thing really sparked a lot of people's interest in these particular subjects, and what I'm seeing is a lot of you know, blaming of the government. They're stealing from us, and there's a trust account, I know there is, there's money in it, it's our trust account, here's the proof. And, you know, really at the end of the day, that doesn't mean anything, because, you know, all these people who are talking about trust don't know the first thing about trust. Don't know the first thing about trust. They're just hollering a trust, like as if they have some right to go into a trust. And it's like, you don't have a right to go into a trust, dog. I mean, you're not the trustee, you didn't create it. So, you know, just some basic trust law, just to study the subject, you know, would clearly let you see that. But another thing that I see is, I see a lot of people saying that, oh, they're taking the country, they're trying to restrict our rights. And let me just say this to you. When you study law, you're going to see that these people have a right to do what they're doing, and they're not taking anything from you. And I think it can be summed up very easily by a quote in the Bible. And I'm going to read this to you right now. I think this just sums up everything. Okay, I'm in the book of Matthew in the Bible, and I'm in chapter 22, verse 16. Now I'm going to start at 15. And this is a story that a lot of you are familiar with. And but there's so much stuff in here that applies today, it's just unreal. And it teaches you a lesson of how you're supposed to think when you think about the government. And I'm going to start at 15, and it says, Then went the Pharisees and took counsel how they might entangle him in his talk. And he sent out unto him the disciples with the Herodians, saying, Master, we know that thou art true, and teachest the way of God in truth. Neither carest thou for any man, for thou regardest not the person of men. Tell us therefore, what thinkest thou? Is it lawful to give tribute unto Caesar or not? But Jesus perceived their wickedness and said, Why tempt ye me, you hypocrites? Show me the tribute money. And they brought unto him a penny. And he said unto them, Who is this image and superscription? They said unto him, Caesar. Then saith he unto them, Render therefore unto Caesar the things which are Caesar's, and unto God the things that are God's. When they heard these words, they marveled and left him and went their way. Now, This is your blueprint for understanding what is going on. Right here, the Pharisees could easily be replaced with government. Disciples could be replaced with agents. Right here, you see they might entangle him in his talk. Today they say anything you say can and will be used against you in a court of law. I mean, and the tribute money is taxes, all right? Tax money. Do we have to pay taxes? All right. All these kind of things you'll see in here apply to today as well. I mean, the principle is exactly the same. And I'm going to get into it a little bit now. And a lot of people may get mad at me. I really don't care because everything I'm going to show you can be verified. I'm not telling you anything that can't be verified. All right. First thing is first. Let's start with some basic stuff so you can understand what is going on. Okay, the first thing we're going to discuss is public and private. Okay. You can't understand nothing if you don't understand this. You might as well put the UCC1 forms down. If you're in court hollering about you're violating my constitutional rights, you need to put it down. If you're in a criminal case and you're going to try to hurry up, run, throw some bonds in, you need to put it down. You need to stop everything that you're doing. Because what I'm about to show you is going to make you understand any and everything in law. You will no longer be confused. You will understand what is going on. I didn't understand what was going on. I was just like you, blaming the government, doing all kind of things. I was right where you're at until someone made me understand the difference between public and private. And this right here is where how you're going to understand what your rights and duties are by understanding how the law is mapped out. Okay, I actually read a book that kind of like impressed this on my mind. It's a book called 1L, and it's written by a man named Scott Turow. And in that book, he outlines 1L means first year law student. And he outlined in his first year law school at Harvard what he had to go through. And that's kind of like what I patterned my studies after. I had to study, look up words. They couldn't come into class and not know every word in the case by memory and all kind of things. And one thing that I found that was interesting about it was in their study groups, they all were jockeying to like outline the law and so forth. And I really understand why you have to do that, because you got to be able to see in your mind's eye what is going on. Like when somebody calls into my show and they give me a scenario, the first thing that I picture in my mind is on what side of the fence is he talking about. If I'm getting a question about child support or a divorce, I know I'm on the private side. It's family law's private side. If I'm getting a constitutional question, I know I'm in the public side. If I'm getting a contract question, I know I'm in the private side. If I'm getting a criminal law question, I know I'm in the public side. You know, it's just as soon as they bring these topics to you, the first thing in your mind should be, is this public or private that we're talking about? Because that's how the law breaks down. And that's the first thing you have to do to understand what is going on and how to get yourself out of this situation. So I'm going to start with the breakdown of the law and explain this. Now, these words, I'll give you a little history behind this. I've been doing this approximately about 2 years, and I met an old man, and he had heard about me, and everybody was saying, hey, this guy's sharp or whatever. And he asked to see my paperwork, and I gave him some paperwork that I copied out of some of the books, like One Man Out, Cracking the Code, different things like that. And he looked at my paperwork probably for about 15 seconds. And he tossed it to the side and he told me, you don't know any law. And I was offended by that. I was like, I don't know any law. He talked about, man, I don't know any law. I've been in the courtroom. I know what to say in court. I back judges down. What are you talking about, man? I don't know any law. I was kind of like insulted by it, So then he asked me, did I know what an antinomy was? And I did know. That's a contradiction in law. I had read it out of One Man Out. He'd actually had the word in there. And when he kind of dropped it on me, it's been a word I'd already studied, and I kind of knew very well. He said, okay. He said, yeah, you're a sharp brother. Okay, I see you got your legalese down pretty good. He said, but you still don't know any law. So I went back and forth with this man for about 3 days. Every time we'd sit down to eat or anything like that, he started, first thing coming out of his mouth, you don't know anything, young blood. He was older than me, he was an older guy. And on the third day, he said it to me again. But, something in me said, humble yourself. And I bit my tongue, and I said, okay, man, what is it that you want to show me? And he didn't spend a lot of time explaining anything to me. He just drew a diagram similar to the one that I'm about to show you. And he told me that I needed to go to the law library and start studying American jurisprudence. And I took the paper back and just looked at it. And I looked at it for about 3 months straight, just kept looking at it and tried to make sense of what I was looking at, but I really couldn't. So the first thing I did was, if I'm going to understand this chart, the first thing I'm going to do is look up every word on it. I'd made that practice, always look at the words, because usually if you don't understand something, if you read a paragraph or something like that, and you don't understand what's being said, 9 times out of 10, it's because there was a word in the paragraph that you did not know the definition. So you have to make it a practice to look up every word in a sentence. And this can help build your vocabulary as well and enhance your reading skills. But you cannot pass over words you don't know the meaning of. So I started basically looking up all these words. And I started with natural law. And natural law was a subject I was already very familiar with. I'd already read a lot of treaties on the subject. In the public, they don't give it the treatment that it should be getting treated. They kind of approach it as some kind of theory or something like that, which they understand what natural law is. They're not fools. I don't think they got in the positions that they are not understanding natural law, but what I do believe is they don't want you to understand it. That's what it is. But natural law basically operates off 7 different principles. And they are vibration, correspondence, mentalism, which everything revolves around the mind, rhythm, polarity, cause and effect, and gender. And you'll see this also in your Bible in Proverbs 9:1, where it says, wisdom has built her house on 7, has hewn out her 7 pillars. And you see this going all the way back to Egypt, where they talk about these 7 pillars that everything in nature rests upon. And there were the 7 that I just named. You can read a book called The Rebellion that goes into that in much more detail. But everything starts with the laws of nature, because nature is not a respecter of persons. Everybody has to draft whatever they're doing in harmony with nature, which is what these people do. These people who are drawing up these laws are not stupid people. They're very learned people. They know what they're doing, and they understand the different spheres and operations of law, including natural law. So from natural law, we get something that is called positive law. And positive law just simply means man-made law. And they are the trustees of natural law. They're supposed to be. In other words, a person really shouldn't be in a leadership position if they don't know natural law, or for all the religious people that are out there, if they don't know the laws of God. Okay? How can you lead if you don't know the laws of God? How can you make good decisions if you don't know the laws of God? And I'm not approaching this from a religious point of view, because everybody knows me, I'm not a religious man. What I'm speaking to you is scientific, because if natural law governs everything, then it should be important for you to know natural law. So that is a very, very, very important thing for you to know. And as trustees, they're trustees of natural law. That's why you hear kings say, I have a divine right of rulership. It's an understanding and knowing these laws that put you on the status and level of a king or a god, where you now qualify to be able to lead people, to govern people, and things of that nature. But you have to know what the laws are, because if you go against the laws, there's a corresponding effect that may not be very pretty. All right? So we can see from positive law, which is man-made law, it branches off into 2 branches, which is called substantive law and procedural law. And I'll read these to you. As I said, I pulled these definitions out of the 8th edition Black's Law Dictionary. And we can see right here that substantive law, the part of the law that creates, defines, and regulates rights, including, for example, the law of contracts, torts, wills and real property, the essential substance of rights under law. Okay, and opposite of that, we have what is called procedural law. Now, that is law that prescribes the procedures and methods for enforcing rights and duties and for obtaining redress as in a suit, and that is distinguished from law that creates, defines, or regulates, which is, of course, substantive law. So you have these polar opposites here, substantive law and procedural law. And procedural law kind of gets into the cause and effect aspect of things. If you do something in a certain way, you'll always get a certain result. And that's why they have procedures that they have to follow. But those procedures are in alignment with the will of the masters who is Congress. But they also are in alignment with natural law. They have to be. Anything that's not in alignment with natural law is going to have a temporary existence. And they understand it. So we have substantive law and procedural law. And from procedural law, we get remedial law, which is that which affords a remedy as a remedial statute, or one that is made to supply some defects or break some superfluities of common law. The term remedial statute is also applied to those acts given in remedy. So from procedural law, we get remedial law. Obviously, if you follow the correct procedure, you'll get your remedy. But from substantive law also has two branches. And that branch is public law and private law. Now, this is something that would be well worth you remembering. You know, I have this whole chart memorized. When somebody says something to me in my mind's eye, I see this chart. On what side of the fence we're talking about? Are we talking about the public, which is the land of Caesar, because that's what public means, government? Or are we talking about private, which is the land of God, which is all the people who are so-called Christians or whatever your religion is? It should be your primary goal to align yourself with God and God's law. And this is where you find your protection, and this is where you find your freedom at as well on the private side. Now, what I see with a lot of people out there, the people who blame the government, is that the people who blame the government don't have any respect for public rights. There's a thing called public rights doctrine. A lot of people out there, they just want to go in and take something because they think something is...
The whole thing will turn red.
Because they think something has been taken from them. And but what it is when you begin to understand the law, okay, it's just like a house. All right, you can live in a neighborhood, but you have your house, okay, and I have my house. Now, you can't walk into my house and just open the door and walk into the house, don't even knock, go into my refrigerator and start taking food out. And then I come into the house and say, hey, look, you know, hey, why are you in my refrigerator? You need to pay me for the food that you ate. And you say, well, no, I don't have to pay you. I'm exempt. But yet and still, you know, you're in my house eating my food, you know. No, you're going to pay for that food. You're not automatically exempt. You took something that belongs to me, okay? So you have to be respectful not only of your fellow man, you also have to be respectful of government, because government has rights too. And I'm going to show you that right now. Okay, and I'm on, look like Wikipedia. And I think this gives a very, very good description of the public rights doctrine. And right here, let me read this to you. It says, public rights doctrine is that some rights are so closely integrated into a public regulatory scheme as to be a matter appropriate for agency resolution with limited involvement by the Article 3 judiciary. Now, and further on, we're going to read what are the difference between an Article 1 court and an Article 3 court, and an Article 1 judge and an Article 3 judge. But notice right here that gets into that. Always remember separation of powers doctrine. Each of the individual branches cannot interfere with the business of the other branches unless they get some delegated authority or permission to do so. And this leads into what is called checks and balances. So what it is under Article 1, Section 8, Congress was delegated powers. Now, they have what are called plenary powers to implement all of those powers that were given to them by the Constitution. The limitations being the Bill of Rights. That's why they call the Constitution a limitation on government. All right, so the thing about it, it's just like me. If I'm in my house, I got all power in my house. Now, when I step outside of my house, there's a different set of rules. But in my house, I'm not subordinate to anybody's rule. That's the legislature. As long as they stay in their house, they're not subordinate to anyone. And as far as them inflicting harm on the private, okay, there are restraints against that called the Constitution of the United States of America and the Bill of Rights and so forth. This is the purpose that it serves. So as you can see, the courts, Article 3 courts will not get into the business of Article 1 judiciaries. They call it a political political question doctrine. And what that means is like, hey, you know, you coming to us for help, you don't need to be coming to us. What you need to be doing is going to the ballot box and making sure the right people get in positions and you be their constituency and they'll fulfill your purpose. You know, that's what they're saying. But, you know, people want to point fingers and blame and so forth and not take the responsibility on themselves. But let's go back to this. It says in 2017, there's a big dispute as to whether parties fall under the public rights doctrine so as to deny patent holders full rights to adjudication by other courts and instead subject them to rescission by the Patent and Trademark Office. And right here, they're just giving you an example of one application of public and private. But the thing is that there's a distinction. Let's go down here and read these. These are all cases. And it says the court expounded on the public rights doctrine in Stern versus Marshall. Stern explained that the court continued to apply the public rights doctrine to disputes between private parties in cases in which the claim at issue derives from a federal regulatory scheme or in which resolution of the claim by an expert government agency is deemed essential to a limited regulatory objective within the agency's authority. What makes a right public rather than private is that the right is intricately related to particular federal government action. And here it is. This is what it is. This is Caesar's territory. Caesar, I guess I can make this very simple. All right, you need to learn how to get out of Caesar's way and stay out of Caesar's business. All right. What I'm seeing is that too many people are involved in the federal government's business, and what they're not focused on is developing their communities, building up their businesses, and so forth, so they'll have power. Because right now, you're all divided, you don't have any power or anything like that, you just want to sit back and complain, and then you're complaining about the wrong thing, because the government is really not doing anything wrong. You know, 90% of everything they do, I think, is pretty much on the mark, with the exception of a few things. But all in all, you know, they're doing everything right. What it is they're looking at you and saying, okay, this guy right here is ignorant, and he could also be dangerous. So let's put a watchful eye on him and check him out. And that's what's going on, all because you don't know the difference between public and private. So let me go back to my chart. Now we're back at our chart. Let's go do public and private real quick. Okay, so now this is the part that you need to remember. If you know this, you'll be better than a lot of the gurus out there, because a lot of the gurus don't know this. Even though this is something that can be very easily verified, reading case law, going to Wikipedia, just almost anywhere, you can see it. But nobody talks about it for some reason. They'll use the word. You hear everybody think public and private all day long. But nobody really knows. If you ask them, well, what is public? Name all the laws on the public side, and name all the laws that are on the private side. So we have public law, which is composed of constitutional law, criminal law, administrative law. This should be public international law. And then they also have what is called tax law that is on this side. All those are in the public side. On the private side, we have contract law, tort law, status law, property law, family law also goes on this side. And then they have what is called private international law, which also goes by the word conflict laws. Now, once you get this down in your mind, and every time you have any discussion about law, and this pops up in your mind, it's going to guide you in thinking correctly. For instance, you start talking about my constitutional rights. Well, constitutional law is in the public. Okay, public means government. Okay, the Constitution is what forms the government, and it also puts the limitations on government. And what limitation is that? Well, it's the fence. It keeps them over here so they don't come over here unless the only way they can come over here unless there's what is called a compelling public interest. And let's look at that real quick. And while we're at it, remember in the Constitution it says no private property shall be taken without due process of law and just compensation. It doesn't say they can't take your private property. It's just saying that they have to give you follow the procedure and they have to compensate you for it. And for them to even look at it, there has to be something called a compelling public interest. Let's look at that word next. Okay, so first we're going to start with the definition of public interest. Now, the welfare or well-being of the general public, commonwealth, appeal or relevance to the general populace. Okay, so that is one definition of it. Let's go to another. Okay, and now I'm in Black's Law 4th edition, and we want to get some in-depth understanding of this word, public interest. Oops. Sorry about that. Right here, public interest. All right, now, let's read this real quick. Something in which the public, the community at large, has some pecuniary interest or some interest by which their legal rights or liabilities are affected. It does not mean anything so narrow as mere curiosity or as interest of particular localities, which may be affected by the matters in question. That's why they put the word compelling in. They can't have just mere curiosity. Now, pecuniary means money. They have some type of money interest in it. But let's see what the expert commentary says. They pull out of the court cases, these citations of authority. If by public permission one is making use of public property, and he chances to be the only one with whom the public can deal with respect to the use of that property, his business is affected with a public interest, which requires him to deal with the public on reasonable terms. Okay, that's Cooley Constitution, all right? Now the next one, the circumstances to clothe a particular kind of business with a public interest as to be subject to regulation must be such as to create a peculiarly close relation between the public and those engaged in it and raise implications of an affirmative obligation on their part to be reasonable in dealing with the public. One does not devote his property or business to a public use or clothe it with the public interest merely because he makes commodities for and sells to the public in common callings, such as those of the butcher, baker, tailor, etc. And there's American Law Review. A business is not affected with a public interest merely because it is large or because the public has concern in respect of its maintenance or derives benefits, accommodations, ease, or enjoyment from it. All right, so right here, we can begin to form in our mind what this public thing is. I'm going to tell you this in short, it means the government. Anything the government is related to, like your public school is government-funded school. But when you're in the public, okay, you're in someone else's house, okay? You're in someone else's house. And let me read you something about public and religion real quick. There is an article, it's on I think I don't know if this is a Jewish page, but it's a religious page. It gets into the right of religion. I'm just going to blow this up a little bit for you. And it's an article that is very interesting. It says religious freedom versus compelling state interest. And state you will see sometimes in place of public because they mean literally the same thing. And it goes on and it talks about religious freedom. But I want to go down here where it starts to say, to protect our special commitment to rights, the court over the last 60 years have developed a way to keep a thumb on the scale. When a law threatens certain fundamental rights, and this is equivalent to private rights, the law defenders assume the burden of proof to justify it. They have to convince the court that, number one, the challenged law serves not just an important public purpose, but a genuinely compelling one. Number two, the law is well tailored to achieve that purpose. And number three, the purpose could not be achieved by some less burdensome method. This method of argument is called the compelling state interest test. Perhaps the single dearest statement of this doctrine is in Wisconsin versus Yonder. And let me show you the compelling state interest test real quick. Now this is how they come over into the private side. Okay, now, I think this one right here is the one that's really going to get you. Compelling state interest test law and legal definition. Compelling state interest test refers to a method of determining the constitutional validity of a law. Under this test, the government's interest is balanced against the individual's constitutional right to be free of law. You got a constitutional right to be free of law?
Huh?
Are you trying to tell me they know that? They know that? They understand that? But what does that mean? You have a constitutional right to be free of law. However, law will be upheld only if the government's interest is strong enough. Okay? What does that mean? Let's see if we can shed some light on this. Go back to our chart. Now, this is the public. They have to have a compelling public interest to come over here and deal with your fundamental rights, which are your rights that are given to you by God, your right to not be under any law or anything like that, which only you're achieving. You have a right to do that. But you need to understand where it is located. It is located on the private side. You can't go into the public making demands, saying somebody owes you something, using their property. That TVA account, that is in the public. It's not in the private. You don't have any inherent right to it. There's rules. Public and private never mix, okay? It cannot mix. They're two separate things, okay? You're in the private, they're in the public. There's a public trust over here, a public charitable trust. They're going to have a trustee of that trust be a public individual. It's going to be the trustee of it. Now, you as a beneficiary, you have a trust certificate that represents your prorated interest in that, and you do have a right for distribution from that, but you don't come over into everything in the public requires you to be licensed, because public safety is their first order of business, to make sure the public is safe, and so forth. If you're teaching something, selling food, doing anything like that, there are regulations over here that you have to abide by. There are procedures over here that are put in place to make sure that everybody does what they need to do and doesn't violate the Constitution. Okay? Also, because there's no money over here, all these people are bonded. They have to be insured in some kind of way. Everything requires some sort of insurance, so there can be some assurance about their performance and their particular duties and so forth. All right, so over here on the private side, everything is governed by contract pretty much. Okay, you have a contract, this contract is I had to locate selling look at the and here it is. I had to locate this. She's selling this now. This used to be on the internet for free. You probably can find it on the internet for free. But you see this marriage contract, and it goes through, the authority. It's real interesting. And at the top it says, "In the name of God our Father and the Lord Jesus Christ, we, in the name of the parties, hereby before these witnesses are joined in holy matrimony as God intended in Genesis 2:21 to 25, from this day forward until death. The authority in and for this marriage of the Almighty God is revealed in the Holy Bible, authorized 1611 King James Version, the Word of God, worship the final authority every day." And then just parties, benefits. Now here you see it talks about mutual rearing of children. It even goes into prohibitions. There's an adultery, abandonment, abortion, all the definitions of everything that you're going through. If there's criminal behavior, dangerous behavior, habitual drunkenness, injection, when the appeal is made, it says the first appeal, when one party believes the other party has violated the prohibitions above, should be in accordance with Matthew 18:15-18, that is, the offended party should take the matter to the accused party. If no resolution results from the first appeal, may demand physical separation from the accused parties to the remedies below, and they actually go through and tell you how your marriage is supposed to be conducted. And of course, you should have some sort of either religion. It should be based off some religion, because everything really on the private side is under God in some kind of way. This is where religion kind of comes into all of this. And while we always say that no one is ever really free from any law, there should be something guiding you in everything that you do. All private people are in a contract, whether you know it or not. There are implied contracts and express contracts. If you're living with a woman, they call that common law marriage. That is a express, an implied contract that exists. You maybe to your advantage to put it on paper. So if a dispute does erupt, now you got the contract that is guiding everything. Get this notarized, both of you see it, go and file it down at the county court or in a public record somewhere or something to that effect. But everything on the private side runs through some sort of contract. And marriage is a good example of that. It's a contract. I study trust law, private trust law. Everything in the entire book is contract. Every single thing. Every single thing that has to be done is a contract for. So understand that when you're on the private side, you're going to be dealing with contracts a lot. Okay? Now, tort, of course, is an injury to a private individual. It's an injury. You file a tort when, as a private person, when you have some sort of injury. And of course, your status, as it relates also, people have different statuses. Property law, which is some of the oldest law in law that has remained relatively unchanged, is on the private side. Also private international law, family law, of course. All these are on the private side. So you got to understand that, you can be free. Yes, you're free from anybody having to do, you have a right not to be under any law. But what you don't have the right to do is to come into the public and violate laws, okay? If you're going to be private, then you have to stay all the way private, but you can't come into the public and start making demands, start talking about constitutional rights. Over here you have constitutional rights. Over here you have constitutionally protected rights, okay? Because the Constitution doesn't give you any rights. As it says, you have a right to be free. Private means the right to be left alone. And if you want to be left alone, as long as you're not bothering anyone or their property, then people are going to leave you alone. But when you start infringing on somebody else's rights, okay, there's going to be a problem. There's going to be something for that. And that is what people have to understand. And stop getting out of here and saying what rights you have and things like that. Half the people who are saying that have never even read the Constitution. But it is on the private side. And I'm going to show you some court case examples that are going to impress that upon you. And I'm going to start with a trust law case on a private trust and let you read this verse, and then we'll show you another example. Okay, here's a case that is definitely worth you studying. It is a trust law case, and it was argued before the Supreme Court. And the name of the case is Evans versus Newton. And I think this is one of the best cases I've ever read where the judge gives you a thorough education on the difference between public and private. And what I'm going to do is I'm going to just give you a quick overview of the case. What it was about is it was about this senator, his name is right here, Senator Augustus Bacon. He executed a will that divided to the mayor and city council of the city of Macon, Georgia, a tract of land, which after the death of the senator's wives and daughters was to be used as a park and pleasure ground for white people only. The senator, stating in the will that while he had only the kindest feeling for the Negroes, he was the opinion that in their social relations, the two races, white and Negro, should be forever separate. The will provided that the park should be under the control of a board of managers of 7 persons, all of whom were to be white. The city kept the park segregated for some years, but in time let Negroes use it, taking the position that the park was a public facility which it could not constitutionally manage and maintain on a segregated basis. You know, they got the Equal Protection Clause under the 14th Amendment now, where in the public they cannot discriminate. Okay, but you can discriminate in the private. And what this was about is that this was a private trust, but they had public trustees administering it. And it all boiled down to whether it was public or private. And I'm going to let this judge tell you what it is. And it's right here, it's explained right here. This judge does a very good job. He said, there are two, excuse me, there are two complementary principles to be reconciled in this case. One is the right of the individual to pick his own associates, as to express his preferences and dislikes, and to fashion his private life by joining such clubs and groups as he chooses. The other is the constitutional ban in the Equal Protection Clause of the 14th Amendment against state-sponsored, read public, racial inequality, which of course bars a city from acting as a trustee under a private will that serves a racial segregation cause. And this is also the reason why in your trust agreement, when you draft one, you can't draft anything that's going to violate any type of public policy or anything like that. That's one of the things you have to do with trust and understand. And now he gives you some examples of what you can do. A private golf club, however, restricted to either Negro or white membership is one expression of freedom of association. But a municipal, read public, golf course that serves only one race is state, read public, activity, indicating a preference on a matter as to which the state must be neutral. What is private action and what is state action is not always easy to determine. Conduct, read minimum contacts, that is formally private may become so entwined with governmental policies or so impregnated with a governmental character as to become subject to the constitutional limitations placed upon state action. The action of a city in serving as a trustee of property under a private will, serving the segregated cause is an obvious example. A town may be privately owned and managed, but that does not necessarily allow the company to treat it as if it were wholly in the private sector. Thus, as we held in Morris versus Alabama, that the exercise of constitutionally protected rights, notice what this judge just said, constitutionally protected rights on that read private rights on the public streets of a company town could not be denied by the owner. A state is not justified, we said, in permitting a corporation to govern a community of citizens so as to restrict their fundamental liberties. Remember, private rights. I notice also that corporations do what? Govern. Right? It's nothing new with these corporations. We've also held that where a state delegates an process to private groups, they become subject to the same restraints as the state. Okay, so if they delegate, the state delegates, remember delegation of powers doctrine, some of its power, and I'm going to talk about delegation of powers doctrine. The private groups, they become part of the state, they become a party to the Constitution. And you learn this in trust law. If the trust contracts, let's say with a contractor, to do some work for the business trust, those contractors have to live by the terms of the trust indenture agreement. Well, it's the same thing when you contract with the government, you have to follow the trust indenture agreement, which is the Constitution. They are trustees, and they can only do what that Constitution says they can do. Just like in the trust indenture agreement, the trustees can only do what the trust indenture says they can do. And if you do any type of business with them, one of it is that you have to agree to the terms of the document, as well as the fact there's some indemnity things that go along with that too, and I'm going to talk about that a little bit. But this particular case is Evans versus Newton. You can see it right here. You can go to Google Scholar and pick this up just by doing a search for private trust. And you see even Evans versus Newton. This is a very, very educational document on public and private. It's all the way through. It goes into it, and you're going to find that a lot when you read case law on private trust. It gets into it more than anything. And that's also when you're going to begin to really understand trust law. I think privacy and versus public. I think the two fields that help you more than anything is tax law and trust law, and studying those things, because when somebody says they're tax exempt or they don't have to pay any taxes, what they're saying is that they're private, that they're not engaged in any business that is within the United States, and no income is coming that has an origin within the United States. Okay? It doesn't matter if you're private. If you're receiving income that has that originates within the United States, there's going to be a tax obligation associated with that. This is what people have to understand when we're talking about public and private. It doesn't matter if the IRS code was never ratified or whatever. You contracted to this. Contract makes the law. They can make up anything, and if you agree to it through a contract, it doesn't matter if it was ratified or anything like that. You agreed to it. This is why Judge said that, they're not going to look at anything constitutional for something that you've been taking a benefit from. And I'm going to show you that right now, where the judge said that. Okay. Understand how the judiciary looks at this public and private thing and whether something's constitutional or not. You need to know this right here. You need to know the Ashwander rule. Okay, this is what the justices go by. Very important for you to understand this, especially if you are looking at public and private. Okay, the Ashwander rules, articulated by Justice Louis D. Brandeis, are a set of principles used by the United States Supreme Court for avoiding constitutional rulings. Now, this is what they look at. If you do a constitutional challenge and they don't look at it, well, it's going to fall within one of these 7 things right here. And that is, court will not pass, and let me go through it. All right here. It says the court will not pass upon the constitutionality of legislation in a friendly, non-adversary proceeding, declining because to decide such questions is legitimate only in the last resort, earnest and vital controversy between individuals. It never was the thought that, by means of a friendly suit, a party beating the legislature could transfer to the courts of inquiry as to the constitutionality of a legislative act. And notice that they're talking about the legislature. We're talking about legislative courts and then trying to take it from an Article 1 to an Article 3 court. Number 2, the court will not anticipate a question of constitutional law in advance of the necessity of deciding it. It is not the habit of the court to decide questions of constitutional nature unless absolutely necessary to a decision of the case. And this is also, I want you to think about separation of powers doctrine while we're reading all of this. Remember, they can't get involved in what's going on in the legislature. Okay, it goes. Number 3, the court would not formulate a rule of constitutional law broader than is required of the precise facts to which it is to be applied. 4, the court would not pass upon a constitutional question, although properly presented by the record, if there is also present some other ground upon which the case may be dispensed of. I want you to think about exhaustion of your administrative remedies. All right? This rule has found most varied application. Thus, if a case can be decided on either of 2 grounds, meaning Article 1 or Article 3, one involving a constitutional question, Article 3, the other a question of statutory construction, Article 1, or general law, the court would decide only the latter. They're going to use this, the question of statutory construction. Once again, why do they do that? Because the separation of powers doctrine, they always got to defer to the legislature first if it is something involving the legislature. They have to respect that other house and make sure that everyone in that house first can give you your remedy before you can take it over there in an Article 3 court. Because you've been busy in that particular house. Those appeals from the highest court of a state challenging its decision on the question of the federal constitution are frequently dismissed because the judgment can be sustained on an independent state ground. Okay? The court would not pass upon the validity of a statute or complainant one who fails to show that he is injured by its operation. Among the many applications of this rule, none is more striking than the denial of the right to challenge one who lacks a personal or property right. If you lack a personal or property right. While not mentioned in Ashwander, there are exceptions in the case of a First Amendment challenge, where the party may raise the effect of the law of the person's First Amendment right, the so-called chilling effect doctrine. Okay, and here's the one that really hits home. The court will not pass upon the constitutionality of a statute that the instance of one who has availed himself of its benefits. So if you've been using these statutes as a benefit, and then later on you want to come around and challenge it, they're not trying to hear that. They're not trying to hear it. Okay? Number 7, when the validity of an act of Congress is drawn into question, and even if a serious doubt of constitutionality is raised, it is the cardinal principle that this court will first ascertain whether the construction of the statute is fairly possible, by which the question may be avoided. They do everything in their power. I prevent you from coming over this Article 3 solely on the basis of separation of powers doctrine. Now you can understand what I'm telling you. You have to understand separation of powers doctrine and delegation of powers doctrine. Alright? You running out there getting mad and you don't understand how the law is constructed. You don't know where your rights are, and you don't know what your rights are. You do have a right to privacy. You do have a right to be left alone. But you got to understand the bounds of that. And this is what I believe the Amish understand. I think they may have some very, very intelligent people in their camp who understand this. And it has to be based off of religion. There is this thing about religion that gets more exceptions than anything else. Is your religion when it's under some sort of a religious banner. Okay, when you're serving God. and so forth. You're following God's law because all of the laws are based off the Bible. Okay? These statutory codes and things like that, they have a root in the Bible. So if you're going to be following God's law, you got a right to do this. All right? I even have a book that talks about the churches. Churches don't have to be 501(c)(3)s. Churches became 501(c)(3)s when they began collecting Federal Reserve notes. Okay? But a church, by definition, is already tax exempt. But they started these 501(c)(3)s, and now they're being taxed, and all kind of things are happening to them. There is a book that you can get off the internet. It's called "In the Grip of Caesar," that goes into that topic about the churches very heavily. Everybody who's listening to this, if you're a member of a church, you should read that book. I think it would be required of you to actually read that book so you can get some sort of understanding of what it means to render unto Caesar what is Caesar, and unto the Lord what is the Lord. A judge even said in that book that, hey, they came into the realm of Caesar. He actually makes that statement talking about a church. Okay, so Jesus understood public and private. You should too. Okay, now these things are going to be required for you to know. These are called the Ashwander rules. Okay, and you need to know this, especially all you Constitution people like constitutions like this. I can't even understand how you can do a constitutional challenge and you don't know these 7 principles that the Supreme Court uses. A lot of guys who are locked up, they kind of understand that because they get back a lot of paperwork where the judges tell them this, but they may not quite understand because they don't know separation of powers of why the judiciary is doing this. It is because of separation of powers. You have to understand separation of powers, what that means, to understand how this legislature is doing what they're doing, how they had the right to create a corporation, that separation of powers. Okay, why everybody's saying, oh, they undermined the government in some kind of way. No, they didn't. They had a right to create a corporation. The thing that they did is they tricked you into getting a contract under that corporation, which is a municipal government for Washington, D.C. And I'm going to see if I can show you the law real quick on that so you can see what I'm talking about. Okay, this book that we're looking at came out of the law library, and it came out of a book, United States Code Services. And I pulled out the first volume of it, which was, and I went to the chapter on Article 1, Section 8, Clause 17, that goes into the 10-mile sphere of Washington, D.C. And right here you can find where it talks about the legislative authority of district. Okay? You need to read this very carefully, especially all you guys out there who keep talking about the Act of 1871. I was meant to undermine, every time I see these guys don't understand law and what they're talking about. But and I can see why people are really nervous and call people threats and terrorists and things like that because of their misunderstanding of the law. And a lot of that comes from a lack of respect for the public, and I think also wanting something for nothing. People don't want to be a people of God. This welfare state mentality, a lot of people don't understand how to do a lot of things for themselves. You're not building your own houses anymore. In a free country, you had to build your own house if you're a man. You had to get your own herds. You had to grow your own food. You had to do all these things yourself. Now everybody's providing you with everything, and you think there's some sort of inherent right to that, when there's no right to that at all. These are privileges and benefits that are being dispensed. If you want to exercise your right, you need to learn how to start doing things for yourself. But right here in the legislative authority of district, Congress has power to invest District of Columbia with legislative authority. Okay, notice that Congress is doing this. And it says Congress had authority under the Constitution to delegate its lawmaking authority to the Legislative Assembly of Municipal Corporation, which was created by Organic Act of 1871. And rightful subjects of legislation within the meaning of the act was as broad as the police power of state. And right here, what I want you to pay attention to is notice how they put in quotation marks, rightful subjects of legislation. Okay, they did a legislation. This is an act. Okay, people say, well, it was made to undermine. I said, you guys don't understand law. You're talking about an act, man. This is an act. Okay, this is not because this is not creating anything. The Constitution created this. That's like me coming in my house and I'm making a rule in my house. I'm making a rule that, okay, everybody has to be in now at 11 o'clock at night. Okay, that doesn't have far-reaching effect.
it only applies in Washington, D.C., and I have the authority to do that because I have plenary power within my scope. Now, the trick may be if, say, the neighbors have children, and they have a contract with me and say, hey, look, you know, we want you to raise our children too. And then I start saying, well, you have your children have to follow the same rules that my children have to follow in my house. They have to be in at 11 o'clock at night. And there's a contract. Yeah, they're not in my house, but they've contracted with me to follow my directives. That's what's happening with everyone with the Social Security card, birth certificate, these franchises, or whatever you want to call it. This is how they extended themselves outside of federal jurisdiction, outside their 10-mile square and their insular possessions, and got you involved in all of this. But stop saying that they, you know, try to undermine something or anything. They wasn't. They had the constitutional authority to create a municipal corporation. Okay? Everything that they do is within their jurisdiction. Okay? They don't act outside their jurisdiction. Okay? You are the one that doesn't understand your jurisdiction and where you're supposed to be. It's like somebody, they got an episode of Ballers right now, the last episode where that wide receiver, he accidentally went to the wrong house and knocked the dude out. You know, he thought he was in his house. He walked in the wrong house. Okay, that's what everybody's doing. You're walking into somebody else's house, trying to give the man and knock somebody else by accident. Police come and snatch them up. Well, you're getting out of your own house. Okay, you're in somebody. There is a